for travel agents to divert business from competitors towards the SAA.
Right.
That resulted in the first damages claim in 2008, which was a confidential settlement out of court. And that was basically for the period 1990-2001. They continued with the practice, and in 2010, the competition authorities found against them again, and we instituted a claim again in 2010, and that was for 2001 till 2006. The amount we claimed for was 172 million, and the court plus interest, and the court filed in our favour for 104.
So, yeah, this is the result of that
exactly.
process.
So the conduct is basically the same as abuse of dominance, paying travel agents to divert customers away from competitors towards SAA.
So 104 million rand, must SAA now pay that to Nationwide, which is not operating anymore?
So basically we are representing the liquidators at the moment, so that will be paid to the liquidators.
So the company's liquidated, but there's
Correct.
a principle here, plus there's money. Obviously, if they're liquidating, they need whatever they can get. More broadly, what effect does this have on the sector? Because what you've just said is that SAA did this and then continued to do it, having been found against once.
Correct.
So when will they stop, is the question, natural question for an outsider.
Hopefully they did. We are not sure, but apart from the Nationwide matter, there's another matter, ComAir. It's public knowledge that their claim is about 1 billion against SAA for the same conduct, the same period, everything the same as the Nationwide claim. They're basically waiting for dates for final argument. So that judgment was, basically we were in court 1 to 29 February this year. They were in court for the whole of April. So that's another damages claim against SAA for the same conduct.
Which they've obviously opposed.
Which they have, but basically that matter has been concluded, except for final argument, and they themselves have to do that and obviously get a judgment as well.
Now, there was another issue where, I think it was Mango, where the chairwoman of SAA admitted, or there was a revelation that they had been advantages to SAA and Mango being together. This was then later denied. I mean, it's a bit complex, but that seemed to be the big picture.
Sure.
So there's a lot going on in this area.
Indeed, indeed. And as I say, apart from that, I mean, these damages claims are also, I mean, it's big. So we'll see what happens in terms of payments going forward. We ourselves, I mean, the judgment came out today. We don't know whether or not they're going to appeal or not. But basically that's due and owing.
Is it possible to argue that if it hadn't been for this activity, Nationwide would still be in business?
Absolutely. That was the conclusion by the Competition Tribunal, the Competition Appeal Court, and the High Court. So it obviously did have an effect. And obviously they will be operational still if it wasn't for that. I mean, it was basically, the judgment said 25% only was a contingency in terms of, if you look at the airline market, so 75% was serviced by travel agents. So 75% of the market, they were denied access because of the abuse of dominance conduct. Only 25%, which was direct sales, internet, that kind of thing, they were basically competing fairly.
So, next step, I mean, you don't expect SAA to pay this tomorrow?
Probably not. So basically, in terms of the law, I've got 15 days to note appeal if they wish to appeal. So I think we'll just wait out the 15 days and see. But basically, as of 11 o'clock this morning, due and owing by SAA to Nationwide, the liquidators is 104 plus interest.
Described as a landmark judgment. That's Lucinda Verster, partner at Bowman, Gilfillan. And that's where we leave it for Business Tonight this evening. In a moment, back with the Money Manager. Have a good evening.